Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications exercise number 9 and 10 on the speed of 90 words per minute. Start. From the above narration, it is no doubt seen that all the three courts have held against the appellant and have sentenced him accordingly. Though in that circumstance, the reappreciation of evidence which led to the conviction may not arise, this court is certainly required to examine as to whether the requirement contemplated under the Act 1954 and the Rules 1955 has been complied with by the authorities as per the requirement in terms of the safeguard provided therein. The primary contention of the learned counsel for the appellant as noticed above is that in respect of the sample said to have been collected on 16/10/1979, the report was submitted by the public analyst on 15/11/1979, indicating that the milk sample was deficient, which was below the prescribed standard, and hence the sample was reported to be adulterated. Pursuant to the such report, a complaint was filed before the learned magistrate on 18/3/1980. Subsequent thereto, the copy of the report of the analyst is stated to have been dispatched to the appellant on 7/4/1980. It is that view the contention has been raised by the learned counsel for the appellant that the same is in violation of the provision contained in section 13(2) of the Act 1954. In this regard, it is contended that subsection 2 to section 13 of the Act 1954 provides that the authority on receiving the copy of the report of the result of analysis and on institution of prosecution forward a copy to the person, and it would be open for such person to make an application to the court within a period of 10 days from the date of the receipt of the copy of the report to get the sample of the article kept by the local health authority analyzed by the Central Food Laboratory. In that regard, Rule 9B of Rules 1955 provides that the local health authority shall send the report based on which the action is taken within 10 days after institution of the prosecution. Such report is to be sent by registered post to the person from whom the sample of the article was taken by the food inspector. In the instant case, the contention put forth is that no such report of the analyst has been made available to the appellant, and there is no proof of delivery of the report. It is contended that even though the prosecution had stated that the report was dispatched on 7/4/1980, keeping in view that the prosecution was instituted by filing the application before the learned magistrate on 18/3/1980, The very alleged dispatch of the report is beyond the period of 10 days as contemplated in the rule as stated above. On this aspect, learned magistrate, while rejecting the contention, has held that the report of the public analyst was sent to the appellant by registered post on 7/4/1980, which is within the period of 20 days, and since such report was sent within a reasonable time, the appellant cannot be said to have been prejudiced in any manner. In the case in hand, the learned Munsif rejected the execution application on the ground that the decree holder took no other steps for proceeding with the execution. Quite obviously, the execution application was not fixed on 11th July 1980 for its hearing. The petition number 49 by 11 filed by the judgment debtor was fixed for hearing, and that petition was rejected on that day. After rejecting that application, the court below further passed an order dismissing the execution case for default on the ground that the decree holder took no other steps. This order was obviously not covered by the provisions of Rule 105 of Order 21, Code of Civil Procedure. Hence, the provisions of Rule 106 could not be invoked. The decree was passed on 4th March 1968. The period of 12 years had expired on 4th March 1968. The execution application was dismissed on 11th July 1980. In these circumstances, the decree holder filed an application under Section 151 Code of Civil Procedure for recalling the order of 11th July 1980 instead of filing a second application for execution. I have already pointed out above that the provisions of Rules 105 and 106 of Order 21 could not be invoked on the facts and circumstances of the instant case. There is no other express provision in the Code of Civil Procedure dealing with the situation which had arisen in the present case. The trial court had not fixed the execution application for hearing on 11th July 1980. It had fixed that date for hearing of the petition of the judgment debtor, whereby he wanted the stay of the execution proceedings till the harvesting was done. That application was rejected by the court below as it had become infructuous. The parties were present before the court. If any steps were required to be taken by the decree holder for proceeding with the execution, the court should have granted time for doing so. Instead, the court below rejected the application in default. The decree holder therefore applied for setting aside that order. Such an order not being covered by Rule 105 of Order 21, Code of Civil Procedure, the application for setting it aside could not be filed under Rule 106 of Order 21. The inherent power of the court was, therefore, invoked to set aside that order. The court below, having found that there were sufficient grounds for setting aside that order, recalled it and allowed the application of the decree holder and fixed 24th July 1980 for taking steps in the case. Such an order could not be said to be capricious or arbitrary. The discretion exercised by the court below in setting aside the order dated 11th July 1980 could not, therefore, be interfered with. In fact, the impugned order was passed in the interest of justice and taking, of course, the notice of the fact that the alternative remedy to file a fresh execution application had become barred by time. The petitioners have thus failed to make out a case warranting interference under Section 115 of the Code of Civil Procedure.